Welcome and thank you for joining us this evening for the QBCC's Changes for Building Certifiers webinar. Before we commence, I wish to acknowledge the traditional custodians of the land at each of the locations that we are at and pay our sincerest respects to elders past, present and emerging. My name is Regan Greer and I will be your webinar MC this evening. I'm going to quickly explain how this webinar will run. Our presenter this QBCC's very own Greg Matthews, Director of Technical Services. Now, there's quite a number of you who have logged in to hear about these new and enhanced laws that commence very soon, which means you're going to have lots of questions. If you do have a question, you won't be able to ask it out loud. However, you can still ask it by typing it in at any time during the presentation. On the right-hand side of your screen, you'll see a task panel, and in there is a questions field. We do have some people on hand who are going to help answer some of those questions as we go. What we will do to keep the flow to the presentation, we're not going to immediately stop when a question is asked. We're going to continue on to the very end. And at that point, we've left some time so we can read out as many questions as possible and provide answers. If there are more questions than we literally have time to answer, what we will do is collate all of your questions and get them answered in writing and email them all out to you in the next few days. Now, we anticipate that this presentation is probably going to run for about an hour to allow for time to answer as many questions as we can. We'll sort of wrap it up if there isn't any questions. Now, both Rix and Abe's have confirmed that this webinar will attract the CPD point. At the end of this webinar, within the next 6 days, you'll get an auto-generated email from this platform, which thanks you for your attendance. You can use that to pass on to get that CPD point. If you do not receive that, please go to the QBCC's Contact Us page on the website, fill out the inquiry form, and I'll confirm back to you in writing as I can compare your name against the attendance record. And then that's what you can show to Rix or Abe's. The presentation will be recorded. We will publish it on the QBCC website in the next couple of days, along with all of your questions and answers. At the conclusion of this webinar, a quick survey is going to pop up. We'd really appreciate your feedback on the presentation and your webinar experience this evening, because what you tell us helps us shape how we will deliver information and education to you in the future. I'm now going to hand over to Greg to commence the formal part of this presentation. Greg, over to you.
Thanks, Regan, and thanks everyone for virtually coming along. I know it's school holidays, and for many of us, there's probably plenty of places that you'd rather be right now. So I really wanted to extend my appreciation and also QBCC's appreciation of you tuning in this evening. Whenever I present to a crowd, I like to break the ice with a joke to lighten up the tone. This is my first effort in presenting a webinar, so it's a bit different with face-to-face, and since COVID has changed the way we do everything. So I tried to come up with a joke about social distancing. This is as close as I could get. Boom, boom. I'm assuming everyone's laughing right now, and I'm sure if you're in the room, that'd be going over beautifully. As Regan mentioned, my name's Greg Matthews and I'm QBCC's Director of Technical Services. I report directly to Yvonne Pengelly, the Assistant Commissioner Technical. I've been with the Commission as long as the Commission's been around in this iteration. So I commenced with the then BSA in 2013, which was just prior to the changeover to QBCC. I'll just give a quick background on the Technical Services Division. Our division is responsible for oversight and strategic management of QBCC's Technical Standards Unit and QBCC's Certification Unit. The Technical Standards Unit monitor active building sites across Queensland in relation to standards of construction. So we proactively inspect sites and engage with licensees to promote good building practice. We also have the power to regulate under the provisions of the QBCC Act if and when necessary. And as many, if not all of you would be aware, the certification team has powers afforded under the Building Act to monitor certifier compliance, investigate complaints made against building certifiers and to carry out audits of building and private certifying functions. Again, we can take disciplinary action against certifiers in relation to unsatisfactory conduct or professional misconduct if and when necessary. Outside of the certification team, QBCC also license and keep a register of building certifiers, including maintaining an online license search function, which provides details of a certifier's license, any restrictions or conditions on their license, and any disciplinary action that may have been taken against them within the past 5 years. So any interested parties can visit the QBCC website and be provided with a snapshot of any certifier's license by searching by either their license number or name. This evening, I'll be presenting an overview of the BIFOLA reforms and with specific reference to how these reforms will impact certifiers on the ground in your day-to-day operations and interactions with your clients, local councils, and obviously building or property owners. So by the end of the presentation, you should hopefully be able to recognise the new key BIFOLA terms and concepts, understand how the reforms impact the certification process, understand how the reforms impact your role as a certifier, feel confident that you know how to comply with the new rules, and importantly, know where to find more information. Firstly, I think it's important for everyone to get a basic understanding around BIFOLA. So a couple of questions, I guess, which are probably being bandied around. What is BIFOLA? What legislation does the BIFOLA affect? Sorry, I'll spit it out. What legislation does the BIFOLA Act affect? When do the changes commence? And what are the overarching objectives of BIFOLA? And from there, we'll drill down further into the changes that will directly affect certifiers and the certification industry. So what is BIFOLA? BIFOLA is an acronym and it stands for the Building Industry Fairness and Other Legislation Amendment Act. The BIFOLA Act is an act that amends the Architects Act, the Building Act, Building Industry Fairness Security of Payment Act, which we call the BIF Act, the Professional Engineers Act, QBCC Act, the Retirement Villages Act, and some miscellaneous amendments to the Fire and Emergency Services Act, the Planning Act, the Private Health Facilities Act, and the Public Health Act. From a QBCC perspective, the changes to the Building Act, the BIF Act, the QBCC Act directly affect some of our powers and the legislative responsibilities under our remit. There's going to be at least a couple of rounds of changes, with the first changes set to commence next Tuesday, the 1st of October. So considering we're less than a week out from 1 October, today we'll be concentrating only on the changes set to kick off in this round. This is a high-level view of BIFOLA. So the main objectives of the BIFOLA reforms are threefold. Firstly, the changes to the BIF Act serve to strengthen the project bank account framework to improve operation of trust accounts. It provides additional ways to protect payments to subcontractors, and it introduces new payment dispute options. Secondly, the reforms aim to promote industry confidence and growth by increasing QBCC's powers to effectively regulate the building industry. And why do we regulate the industry? Well, we regulate the building industry in order to guarantee the financial sustainability of contractors, the level of qualifications and building safety standards, and to protect consumers and the community. We aim to achieve this through a range of mechanisms, including licensing, requiring minimum financial requirements and reporting, monitoring for non-compliance with building industry laws, and enforcing penalties and offences where applicable. New powers under BIFOLA to allow QBCC to exclude persons who are not considered fit and proper to hold a licence, and changes to the MFR reporting, which is again the minimum financial requirements, will enhance industry confidence. Several changes to existing offence provisions and introduction of new penalties for non-compliance will support QBCC with taking action against misconduct in the industry. And thirdly, the reforms actually align with the initiatives outlined in the Queensland Building Plan, which were aimed at addressing problems and improving standards in the building industry. So these initiatives were government election promises. Hopefully that provides a high-level view of the wider BIFOLA changes. And earlier this week, QBCC actually presented an in-depth webinar in relation to the changes to the security of payments laws. and it's my understanding that the session was recorded as this one is tonight and can be made available for those who are interested in those changes. Okay, so we're just moving on to the main topic of this session, which is to provide an overview of the main changes affecting certifiers. The reforms to the Building Act are aimed at improving consumer confidence and strengthening the certification and inspection process by clarifying that the duty of certifiers is to act in the public interest, enhancing owners' rights. So, additional ability for owners to request and receive non-mandatory building inspections and inspection documentation that they might not have previously had. Introducing a demerit system. So this is introduced for certifiers in line with the other building and construction industry licensees. Improving professional standards by requiring the accreditation standards bodies to have their professional development schemes regularly reviewed. And in the future, it's not in this round, but providing alternate licensing pathways for building certifiers to access. The topics we're going to cover today are firstly, some changes to the obligations on clients and certifiers to provide certain notices, including new or revised timeframes in relation to provision of those notices. The new provisions to allow an owner who's not the client to request certifier inspection documentation prior to the final inspection. The new ability for an owner who's not the client to request additional certifying functions. Clarification that the primary, as I mentioned already, the clarification that the primary duty of a certifier is to act in the public interest above all else. Some changes to the required timeframes for certifiers with keeping inspection documentation. I'll go into that a little more in detail. The introduction of certified demerit points and disqualification. Some limitations on making minor complaints about building certifiers to QBCC, including powers for the QBCC to dismiss certain complaints without further investigation. And as I mentioned, also in relation to accreditation bodies, there just a change to the Act that they're prescribed by regulation rather than being named within the Act. And there's some terminology changes which we'll also touch on as we go through. Oh, sorry. Okay. We'll get into it in a little bit more detail now. And just a quick reminder, don't forget to post your questions as we go, and I'll do my very best to answer them at the end. So Section 143 of the Building Act, which it relates to the provisions around notification of engagement. The previous or the current version of the Act noted that a private certifier should give notice of his engagement to the local government within 5 business days after the commencement of the engagement. And this section also noted that the owner of the building, or if the owner of the building isn't the client or the applicant, so for example, the certifier is engaged by a third party, such as the builder, or it could be an architect or a project manager, the certifier is to provide details of their name and their responsibilities to the owner within 5 days of their engagement. So everybody should be across that. That's an existing provision. This provision was potentially problematic in cases where the client didn't pass on the owner's details to the certifier, and there was no means of holding the client to account under the provisions of Section 143. So the changes to 143 break down the requirements based on 2 scenarios. Either the owner is the client or the applicant, or the owner is not the client or the applicant. In the case where the owner is the client or the applicant, the requirements basically don't change. And the certifier must notify the local government of their engagement within 5 days on a Form 56, which is a notice to the local government that a private certifier has been engaged. The new 143A prescribes a case where the owner is not the client or the applicant. In this case, the client, so the person engaging the certifier, has 10 days to provide the certifier with the owner's details. This holds the client to account for providing the certifier with the applicable details, and there's an offence penalty of 20 penalty units should the client fail to comply. And I could pretend that I'm calculating it in my head, but 1 penalty unit is currently $133, so 20 penalty units equates to $2,660. In turn, the certifier has 15 days from the commencement of their engagement to notify the local government of their engagement using the Form 56, and similarly has 15 days to notify the owner of their name and their responsibilities using the Form 18 notice. So this would mean, just calculating timeframes, if a client takes the full 10 days to notify the certifier of the owner's details, the certifier still has 5 days, which is in line with the original or the current Section 143, to provide the Form 56 to the local government and the Form 18 to the owner. And under Section 143A(5), the client also has an obligation to notify the certifier of any changes to the owner's name or contact details within 5 days of becoming aware of the change. All the relevant forms and templates, if there are changes to existing forms, they'll soon be available at the Queensland Business website, which is the web address shown on the bottom of the slide there. So the next change relates to obtaining or the owner's ability to obtain certification documents. So there's a new Section 124A, which relates to a certifier's obligation to give the owner inspection documentation for particular inspections upon request by the owner. So at any time prior to the final stage inspection, the owner may request copies of any inspection documentation for any completed stage of the works that the certifier has inspected. This will serve to enhance the owner's rights by adding transparency to the process and providing peace of mind, particularly in cases where the certifier may be engaged by a builder or another client, and the owner has no oversight over the certification of their building till after completion. For this notice, the certifier has 5 days to comply, and again, it's a 20 penalty unit fine, which is $2,660. And as shown on the slide there, there'll be a suggested template on the QBCC website, which can be used by owners to make a request under 124A. That's not a compulsory form, it's just a suggestion to make it easier for the owner. Additional certifying functions. So Section 143B is a new provision allowing the owner to request additional certifying functions over and above the responsibilities noted in the Form 18 under 143A. The certifier is entitled to charge for additional functions, and the Act states that the owner is liable for reasonable costs of the extra function. As far as what might constitute reasonable costs, this would be a commercial decision, so there's no guidance in any of the changes, but certainly it's a commercial decision that an individual certifier would need to make in the course of their day-to-day activities. Again, in relation to how the contractual aspects of the situation would be managed, the suggestion at this point is that it could be a question for the PI insurer or your legal advisor. Because it's the owner that's engaging the certifier for the performance of the additional certifying function, the certifier should discuss the terms directly with the owner. The certifier may need a separate engagement agreement with the owner for the additional functions. These provisions only apply if the owner is not the client and the owner is to make the request to the client within 10 business days of receiving the Form 18. In turn, the client's then allowed 5 days to notify the certifier of the request. And so working through those timeframes from engagement of a certifier, this would mean that potentially if every timeframe goes right to the limit, an owner request for additional certifying functions may reach the certifier 30 business days after the date of engagement. The building certifier, the client, the owner must then come up with an agreed day or an agreement to determine the agreed day to perform the additional certifying functions. They need to come up with the date or the agreement within 10 business days of the certifier being informed of the request for additional certifying functions. And just in relation to what an agreed day might constitute, it could be considered unreasonable or impossible at the very start of a program for the parties to agree on a particular date for those extra functions. You know, given the possible changes in programs and all other reasons for delays or not knowing exact dates. So that the agreement to determine the agreed day would be something like, if we had an example of the extra certification functions was in relation to waterproofing, for example. So the agreement would be that the agreed date would be after the completion of the waterproofing and before the commencement of tiling works. So we don't have a date on it, but we have a period in the program that's applicable, that everybody can understand that that's the time that the function would be undertaken. If the client and the owner and the certifier can't agree on the agreed day or the way to determine the agreed day, it falls back onto the certifier, and it becomes his or her responsibility to make the determination and notify the other parties within a further 5 days. So 15 days after notification from the client that the additional functions are required. The certifier would then perform the additional function on the agreed date and provides copies of the relevant documentation to the owner and the client within 5 days of the completion of the function. And at this point, there are a lot of dates and timeframes that it's probably quite difficult to get your head around exactly how that may work with a program. So currently we're working on a flow chart which will aid with identification of those timeframes, and once we have that up to speed, we'll post that on our website, and that may just give some clarity over those timeframes. So other certifier requirements. This is not a new one, but basically in relation to certifiers having a duty to act in the public interest at all times, that's not a new requirement. The changes in section 127 and 136 of the Building Act relate to the changes relate to a note only that the duty to act in the public interest prevails to the extent that there may be any inconsistency with any other provisions within the Act or to another person. So in other words, the duty to act in the public interest prevails over any other duty to the client or other person or other thing. Another change is the changes for timeframes for keeping documentation. So section 150 is amended to increase the timeframes for keeping documentation from 5 years to 7 years. This timeframe aligns with the timeframes which I'll discuss in a little while relating to the cut-off day for making a complaint against a certifier. So we'll look at those timeframes, as I said, in a few minutes on a next couple of slides. In relation to the accreditation bodies, the previous section 184 noted that noted ABES in the provisions, and then any other entity prescribed under regulation. So the revision to the Act in that respect removes a reference to ABES and leaves all accreditation bodies prescribed by regulation. So up on the screen now, we have some changes to terminology. Some would be no surprise, and that they are, basically in relation to changes in terminology within the National Construction Code. So the clarification that the BCA under section 12 is volumes 1 and 2 of the NCC, the National Construction Code, and use of the word performance solution as opposed to alternative solution, which has been changed in the BCA for a little while now. Two new ones are the change from certificate of classification to certificate of occupancy, and the change to the heading of section 33 from boundary clearance and site cover provisions to design and siting provisions. And then a further change is that the definition of the Queensland Development Code, which is in section 13 of the Act, has changed to note that the QDC will be prescribed by regulation. So we've just covered a range of changes to the role and the functions and the obligations of certifiers. We'll now turn to look at some of the changes introduced by BIFOLA that enhance the way QBCC regulates licensed certifiers. The key change here is the application of the new demerit points to certain offences. Demerit points will be applied to a certifier's licence for certain building certification offences committed from 1st of October 2020. Demerit points won't be allocated for offences committed prior to 1 October. We hoped to have a list available today of the demerit points for specific offences. Unfortunately, we're yet to receive these from the department, but they'll be listed in the Building Regulation 2006. So how are demerit points allocated? So when someone has a conviction for a demerit offence, the QBCC must allocate to the person the prescribed number of demerit points for the offence as soon as practicable after the points take effect. The points take effect upon conviction, and convictions are defined, it's a defined term under section 214A of the Act. So conviction of a person for a demerit offence includes a court finding the person guilty or accepting the person's guilty plea for an offence, whether or not the conviction is recorded, the person paying an infringement notice fine, either in full or a first instalment, or the registration of a default certificate with SPUR, the State Penalties Enforcement Registry, for an unpaid infringement notice. So if a conviction for a demerit offence is appealed, the demerit points won't take effect until the appeal is heard and finalised. The number of demerit points for an offence depends on the type or the severity of the offence, but it's up to 10 demerit points for the most severe offences. And under section 214G, there's a maximum of 20 demerit points per single audit or investigation. This will eliminate the possibility that multiple minor offences, say for example, administrative errors that might be uncovered during an audit, it eliminates the possibility that they could result in disqualification due to accumulating a large number of demerit points in one hit. Section 214G of the Act will provide further scenarios also in relation to the accumulation of demerit points and how that will occur. And details regarding the allocation of demerit points, they'll be sent to the licensee, so the licensee gets notified, and it's also published on the QBCC Certifier register. If a certifier has issued 30 or more demerit points within a 3-year period, they may be disqualified from holding a building certifier's licence. So the disqualification process is typical of a show cause type process where the QBCC will issue a notice of proposed disqualification for the certifier. The certifier then has the opportunity to come back and provide submissions in relation to that. QBCC then will make a decision to disqualify or to take no further action. Assuming that the QBCC makes a decision to disqualify, the certifier will be disqualified and the licence is cancelled. So for a first offence, it's up to 1 year. And if you've had a disqualification within the last 10 years and it's a second offence or subsequent offence, the disqualification can be up to 3 years. This disqualification information is published on the Certifier register, which is online. If QBCC's decision is that the certifier is a disqualified individual, those decisions are reviewable decisions, so both internally through QBCC's internal review process or externally through the courts. And information in relation to how to request a review, so the review rights, they'll be provided on the certifier's disqualification notice. The Certifier register. So the Certifier register, there's some new information that will be shown on that, which I've just touched on. So in addition to the existing requirements, the Certifiers register will also detail any demerit points that have been allocated to a certifier, the demerit offences and the dates the points took effect, and if the building certifier has been a disqualified individual, details of the circumstances that led to the disqualification. And as I've mentioned it probably 3 times now, the building certifier register is available on the QBCC website. as you can see. This is a snapshot on the screen at the moment of the QBCC website and where to find the Register of Building Certifiers. Okay, so there's also changes to the certifier complaints process. So previously under section 194 of the Act, if a complaint was properly made to QBCC, it was mandatory for us to conduct an investigation in relation to unsatisfactory conduct or professional misconduct. Under section 190, the QBCC could dismiss complaints if further particulars were required but not given, or if the further particulars weren't verified by StatDec. So under the revised section 190, the QBCC may also dismiss a complaint if they're satisfied that the complaint's frivolous, vexatious, or lacking in substance or credibility. This will enable increased efficiencies and potentially save valuable time for QBCC and certifiers alike. There's also new timeframes for complainants to make a complaint to QBCC. Previously, a complaint could be made many years after the completion of the work, and that was always creating difficulty with retrieval of documentation, inspecting or verifying aspects of an investigation. So under the revised 190, a complaint may only be made before the cut-off day, unless the certifier's conduct has or may have caused significant financial loss or other serious harm. So in the Act, cut-off day, so in relation to certification of building work, which is the subject of a building development approval, the cut-off day is 7 years after the certificate of occupancy or final inspection certificate is issued for the building work, or if the building development approval lapses before a certificate of occupancy or final inspection certificate is issued for the building work at 7 years after the building development approval lapses. For conduct relating to building work for which a building development application has been made, but paragraph A doesn't apply, so in other words, there's no building development approval, the cut-off day is 1 year after the private certifier is engaged for the application, or if a private certifier isn't engaged for the application, it's a year after the application is received by the local government. And then otherwise, in other cases, it's 1 year after the complainant becomes aware of the conduct. So I know that was a lot of information in a fairly short amount of time, but just to recap, BIFOLA has made important changes to the Building Act, including the demerit points and disqualification of the licensed building certifiers that we've talked about, changes to what's displayed on the online certifiers register we talked about, the process of making complaints about building certifiers to QBCC, the minor updates to terminology, reinforcement of the duty to act in the public interest, the obligation to give an owner certain inspection documents if they request them, and then the timeframes around notices required to be given by building certifiers and clients during a building project, and the option for the owners to request additional inspections. And again, these new requirements all apply from 1 October 2020, which is next Thursday. So further information, for any further info, you can head to the QBCC website, www.qbcc.qld.gov.au, and click on the New Laws tab. So in the New Laws tab, there's a section on BIFOLA, and there's also a separate recap of the main changes for certifiers, amongst plenty of other valuable information.